Good afternoon and welcome to your Johnston County Board of Education special session meeting. At this time, I'll call it to order. Ms. Dance, we do have a quorum. All 7 board members are here. We will start with the invocation by Mr. Mike Wooten, followed by the Pledge of Allegiance by Ms. Lynn Andrews.
Students and families as they start school Monday, I pray that they come to school with a fresh mind, ready to learn, and we're all safe about it. Be careful, give you all the praise and every decisions made here tonight. In Jesus' name we pray. Amen.
Join me in the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
At this time, I'll entertain a motion to go into closed session for the purpose stated on our agenda. Motion by Mr. Byrd,
Second.
second by Ms. Sessoms. All in favor say aye.
Aye.
All opposed, motion carries 7-0. We'll now enter closed session. Yes, sir, thank you. While he's doing that, I just want everyone to know that I asked Rod to bring these documents tonight to the board meeting in order to ensure everyone saw them at the same time, and we did not receive them earlier this afternoon. So that is the reason we're reviewing them right now.
And for the record, I do have extra copies if people in the audience want to see what the board is looking at. And we're also going to post these, I'll send you those in a second. We're going to post these on Assembly here shortly. Yeah, well, we'll see if we can.
While everyone's reading that, I'll just do a little bit of the overview. I asked our firm to investigate an allegation that board member Ronald Johnston secretly recorded a discussion among board members during a closed session meeting of the board about the topic of administrative salaries, and then played a portion of that recording for an employee after the board meeting. We were also asked to determine whether the alleged conduct, if substantiated, constituted violation of Board Policy 2120, Code of Ethics for School Board Members. And the weight of the evidence obtained, including information provided by board members and JCPS staff, supports a finding that Mr. Johnston secretly recorded a portion of the board's closed session meeting on May 31st, 2022, and after the meeting played a portion of the recording for employee A. Further, Mr. Johnston acknowledged that he has recorded board members on approximately 10 occasions since January 2022 without telling them he was recording, and that one discussion he records pertains to JCPS business. These findings support the conclusion that Mr. Johnston violated Board Policy 2120, which prohibits board members from making secret recordings of JCPS meetings or in connection with JCPS business.
correct version to Ms. Dan. She's gonna post it on the system. You may not even see it, but, you know, the people in my office are perfectionists, so we want to correct that.
With respect to the specific allegation, the greater weight of the information described above supports the following findings. Mr. Johnston recorded board members discussing the issue of administrative salary without telling them or indicating that he was recording. This discussion occurred during the closed session board meeting on May 31st, 2022. After that meeting, Mr. Johnston played for employee A some portion of the recording of the discussion. These findings support a conclusion that Mr. Johnston violated Section B7 of the Code of Ethics, which prohibits board members from making secret recordings at board meetings or otherwise connected to the business of the board. Further, the greater weight of the information described above also supports these additional findings. Since January 2022, Mr. Johnston has recorded board members on approximately 10 occasions, and he acknowledged that one of these recordings pertains to JCPS business. Mr. Johnston did not tell or indicate to board members that he was recording them on any of these 10 occasions. As Mr. Johnston has admitted that he recorded board members on at least one occasion while they were discussing JCPS business, then irrespective of the allegations about a recording of a closed session meeting, Mr. Johnston has, by his own account, violated Section B7 of the Code of Ethics. At this time, I'll open it up for any questions or discussion.
Just to clarify for the people who may be watching, you read the introductory portion of the report and the conclusory portion of the report. You did not, because it would take too long, read the entire report, but it is available for the board to read, and it's now posted for anyone who's watching.
Any questions or discussion about this piece?
Mr. Chair, based upon violations of Board Policy 2120 as evidenced by the investigative report, submitted by the Tharrington Smith Law Firm, I make a motion to censure Mr. Ronald Johnson.
I have a motion on the floor to censure Mr. Ronald Johnson based on the information based in this report.
I second.
Second by Ms. Lynn Andrews. All in favor, say aye.
Well, we're gonna have discussion on that.
Sure.
So when we talk about violations, and you talk about discussions of these matters, and first I want to address what's in this document. Employee A told employee B, who told somebody that I did something. Now, when they say the greater weight, of course it's going to be the greater weight, because I'm not going to participate in this investigation, which I think is a witch hunt for me based on other information that surfaced last week. So the greater weight is going to be in your favor because I refuse to participate in what I believe is a witch hunt for an ongoing series of problems that we've had. But since we're talking about this particular incident, which I don't have any or no recordings, obviously you're not going to be able to produce any recordings. Let me say that again because the microphone wasn't on. I don't have any recordings. There are no recordings, so you're not going to be able to produce any recordings. You're going to be able to produce employee A told employee B that I did something. So let's just make that very clear and just get rid of this document. And let's just forego the formality that is reading this. Now, when we talk about this particular incident, we can talk about board policy, but we can also talk about Tully versus Wilmington, where you treat someone in an arbitrary and capricious manner. And when I say that, let's just say there were 20 names on the list and salaries were being discussed, not just for everyone, but for one person, because one person was singled out for an obscure piece of criteria that's not relevant to a job description. You pick one person and you want to reduce their salary. And in that meeting, I told you you couldn't. I said, you can't do that. Someone told me to pipe down and wait until it was my turn to speak. Someone else told me, I'm gonna finish.
Mr. Johnston.
No, I'm gonna finish.
Mr. Johnston, if you're gonna,
I'm not gonna finish.
if you're gonna continue in that tone of voice, no, you're not.
Allow me to change my tone of voice.
Mr.
Because
Johnston.
it's not the tone, it's what I'm saying that's bothering you.
No, it's not.
Okay, well then I will change my tone of voice in order to get my point across.
Mr. Johnson, one more time and you're not gonna speak.
Yeah, I'd like to see you not make me speak. Yeah, I'd
not-
like to see you not make me speak.
We're going to a
because you
vote.
don't want
We're going
you
to a
don't want the
vote.
truth to come out.
All in favor say aye. Motion carries 6-1. Thank you.
Mr. Chairman, based on the information that we received from
Thing that we were asked to investigate also, that, I know the second report, maybe I should have handed them both out at the same time.
Consistent with Board Policy 2610, I asked our firm to investigate an allegation that Board Member Ronald Johnson attempted to interfere in a student assignment matter involving 2 special ed students. We were also asked to determine whether the conduct, if substantiated, constitutes a violation of Board Policy 2120, Code of Ethics for school board members. The weight of the evidence reviewed, including information obtained from interviews with multiple staff members, supports a finding that Mr. Johnson asked a Johnston County Public Schools principal to modify the school assignments of 2 special ed students as a personal favor. As such, the weight of the evidence reflects that Mr. Johnson's conduct violated the board member commitment and code of ethics for school board members to refrain from using the board member's position on the board for personal gain or partisan gain. I'll give you time to read these at this time. The weight of the evidence supports a finding that Board Member Ronald Johnston sought to interfere with the school assignment of 2 special ed students for personal reasons. The only information received regarding Mr. Johnston's motivation for making the request to move the 2 students was, 1, the school principal's account that Mr. Johnston said parent A had turned on him and that pulling the reassignment for students 1 and 2 would do him a solid, and parent A's account that Johnston had personal issues with him. Nothing in my review reflects that Mr. Johnston had any legitimate educational interest in requesting that the 2 students be removed from the school. The review also supports a finding that based on the conduct described above, Mr. Johnston violated the commitment in the board member code of ethics to refrain from using board members' position on the board for personal or partisan gain. At this time, I'll open it up for discussion.
And again, you have someone said that someone said I did something. And I don't even know if I want to begin a response, Mr. Sutton, because you have showed your true cowardice by not allowing me to finish. And whether it's my tone, I don't think that's it. I don't think you like what I'm saying. I'm familiar with this individual. This did not happen. I have done nothing but help this individual throughout the course of 20 years. So his information is incorrect. And again, you will not be able to produce anything other than someone said that I said something, or someone said they heard that I said something. The greater weight will be given to information you have because, again, I refuse to participate in this witch hunt. This is a witch hunt. I mean, you're saying the greater weight, like it holds some evidentiary value. In my line of work, this is hearsay. Somebody told somebody that told somebody. So I will let this conclude, but I think the board should be ashamed that we bring this all up. But because of the volume of my voice, you don't want to hear what I have to say. When I respond to your allegations, you shut me down. That's not due process. So go ahead and do what you do, ma'am.
We will, Mr. Johnston. Thank you.
Well, I just want to confirm that both parties involved with this particular, the parent and the principal confirmed what had happened. That's what this write-up is telling me, right?
Yes.
The parent of student A and B and the principal that was that you talked to, or one of the attorneys talked to, confirmed that this did indeed happen.
The report.
Indicates that they give a positive to the fact that, yes, this did happen.
Yeah, and that's what the report says, that when well, the report, I mean, he is using the correct language, that says the weight of the evidence supports that finding. So what Patricia is saying in this is that when she weighed all the evidence, that is a reasonable conclusion that she made.
Mr. Malone, outside of, we have had a motion and a second and approval to censure Mr. Johnston. Outside of that, what is the other items that the board has for options in regards to this matter?
So you censored him, you voted to censor him based on the first report. I don't know that you acted on the second report. But to the extent that your question is what other options might be available to the board, as I've explained to you individually, the board doesn't have the authority to remove a school board member. The statute that governs, there used to be a statute back before 2009 that would allow the Board of Education to remove a member, but that was changed. And now the statute that governs that is 14-230. And the district attorney's office, since that's a criminal statute, that is a criminal statute, since that's a criminal statute, the district attorney's office would have to decide whether or not to prosecute someone under that statute for their removal, and ultimately, it would be the court that would decide
Yes, sir. Thank you.
Well, I can't think of a time where we've actually been able to focus on students in the past several months. And based on these investigations, we received information from our attorneys. I make a motion that we ask Mr. Johnston to resign by Friday, the 26th at noon. In failure to do so, to allow our chair to get with the attorneys and submit a letter to the DA to have Mr. Johnston removed from the Board of Education.
We have a motion. Do I have a second?
Second.
I have a motion by Mr. Wooten to ask Mr. Johnston to resign from the Board of Education by Friday at noon, August 26th. And if he does not do so, draft a letter on the board's behalf to have the DA remove Mr. Johnston from the Board of Education. We have a motion and a second. Any discussion?
I do. In 2020, I received 53,011 votes because the people put me here. People wanted me here. And you can laugh at that, but that's the will of the people. They wanted me here. And if you take away 10,000 or 15,000 votes, I still would have had enough votes to be on the Board of Education. So you're circumventing the will of the people and threatening me with some type of prosecution or removal based on these investigations that are filled by hearsay, because you don't. This is the biggest case of whistleblower blaming based on that recording that came out last week. You don't like what I did. You do not like what I did, therefore you are initiating this. This is outrageous. This is in strict conflict with what the people of this county said they wanted less than a year and a half ago. So I would ask you 6 or whatever, 5 elected officials and 1 appointed official, I would ask you, is that truly how you govern? In conflict with the will of the people. So we're fine. You don't have to respond if you don't want to, but I welcome it.
Sir, you have abused the trust of your office.
Based on what?
These 2 reports.
That
You have
are hearsay, Ms. Sessions.
You have abused the trust of the people who voted for you. And that is a shame, because that trust that you have broken by violating the Board of Ethics has cost our children.
Hasn't cost our children.
It has cost our children in time. It has cost our children in legal fees. It has cost our children in morale. Every person who holds this seat is a role model. A role model to be that our children look up to. And so you have abused the trust that was given to you based on your election. And that's a shame. And I'm just going to say, I have been a part of Johnston County Schools since 1991. I have always been proud to say that I was a part of this school system as a teacher, as a leader, and an elected official. I don't know of a single time in the history of this school system where board members had to resort to actions like this.
Allegedly resort, Ms. Sessoms.
Sir, let's just say this, and this has very little to do, but it's hard for me to believe what you have to say. There evidently is enough evidence for you to be suspended from the police department without pay. That in and of itself makes it hard for me to believe what you have to say. And I don't know.
I have no knowledge of that. So you're speaking to something that you have zero knowledge on, Ms. Sessoms, and drawing a very strong conclusion.
Let me say something. The citizens of Johnston County put us in this seat. And they put us in this seat to serve the school system. And that's what we're doing tonight. We're serving Johnston County Public Schools because our focus is going to be on students. It's not gonna be on what's being taped and what's being said. We're doing our job tonight, and I believe that with all my heart.
And if everything we say is focused on students, we shouldn't be concerned about what's being taped.
Why do you have to tape it then, Mr. Johnson?
I think we're
Because
ready
if
for
I
a vote.
assert that it happened, people will say it didn't. Much like you
Johnson,
did in 2019 when I
Mis-
said something happened and you could not recall.
Mr. Johnson, I don't need to go around taping anybody. You probably have archives of tapes of everybody in this room. But that's okay. You admitted you've recorded us on 10 different occasions. You've used whistleblower way out of proportion. This is not a whistleblower. This is something you violated.
Mr. Chairman, I call the question.
Thank you.
So, just so I can be clear, I would be good to get a little bit of direction if you are to pass this motion, and maybe you can wait till it passes, as to what you would want to appear in that letter to the, okay.
We have a motion and a second. At this time, we'll go to a vote. All in favor, say aye.
Aye.
All opposed? Motion carries 6-1. At this time, we need to discuss what exactly we want to have in the censure, so Mr. Malone can draft that up for our approval tonight, as well as have discussion as far as what you would like to see in the letter that we're going to submit to the district attorney's office based upon Mr. Johnston's decision.
That's the to-do list. Then the other question is whether the board is going to take any action relative to the second report. Because you've not, other than some discussion of the second report, you censored based on the first one, but not the second one. So that's just something to make sure that we get covered tonight, one way or the other. I'm not suggesting that you need to do anything. I just want to make sure that you didn't overlook it.
At this time, I make a motion that based on this second report, as evidenced by this investigation and submitted by Tharrington Smith Law Firm, violations of Board Policy 2120, I make a motion to censure Mr. Ronald Johnson.
We have a motion. Do I have a second? All in favor, say aye.
Aye.
Aye. All opposed? Motion carries 6-1. At this time, we'll have discussion on, well, I'll tell you what, we'll take a small recess.
No, if you don't mind. I think that if you're going to want me to draft something, if you could give me some direction about what you would want to include in it, that would be good. I mean, if it were just me doing it based on what you said, I would try to track these reports as much as possible, possibly attaching them as an exhibit or something. But I need to know from you what you might want to have this look like.
What's the pleasure of the board? Would you like for both of these to be attached in the referenced in our letter that we submit into the district attorney's office as evidence?
So, and just to clarify, Todd, I think there are two separate things. There's the
One's a censure, right.
document, which we can deal with first, and then I think the question separate from that is the letter to the district attorney's office, like, I would want to get some guidance from you as to what you would want to notify her about that you would want to have investigated as part of this process by her office. But let's start with the censure, and then maybe while I'm working on that, you can be thinking about the letter.
You know, from my standpoint, the second issue of interfering with the child's, any student's rights to transfer or parent requesting things, to me is the more severe. And I'd certainly think that should be the point of reference in terms of activity that is certainly tends to look like it's an abuse of power based on the review that we've gotten here.
And it's absolutely untrue.
So you're speaking more about the letter to the DA? Correct. Okay. I would certainly believe that as well.
I agree.
Okay, so in regards to the censorship, what type of information would you like Mr. Malone to include in that?
Like I said, I can reports if that's.
That's what I would do.
mean,
I think, yeah.
I would say you would have to track it.
Any additional items? Mr. Malone, I think it's just tracking the reports.
Do you want to attach the reports as an exhibit to the resolution?
I would think we would want to give the DA all the information we have based on what our attorneys have done and what they have found, their findings, and then let the DA proceed from that point.
Yeah, and also especially with the district attorney, I know you will, but, you know, when you reference our policy, just make sure we're referencing general statute. That this policy is particularly 115C 3647 and particularly 160A-86, 87. I'm sure you'll do that, but make reference to our policy, but also to the general statute that covers that policy.
Any other additional items?
So just, because they're two separate issues. Right. So there's the drafting of a censure that you would, like a resolution, is historically kind of how people have done that. So in that document, it sounds like you're asking me to kind of track the two reports, both reports, and to create a censure based upon those reports and those findings. Is that what I'm hearing? Okay. And then we'll deal with the letter after I get this done. Is that easiest? Okay. Yeah. All right.
So we'll take a 5-minute break,
Well,
or a 10-minute break. Yeah, yeah.
come out of the recess.
At this time, we'll go back, we'll adjourn from our recess and go back into open session. Mr. Malone, do we have a microphone so he can? Okay, all right.
So this is a draft, I mean, it's for your review, we can tweak it if we need to. It kind of relies heavily on the information we've already received. Obviously not going to restate a lot of that, but to reference it in this. And you got one and some for others. And Cynthia's gonna put it in assembly if it's not there.
Has everybody had a chance to read this resolution that was drafted? Yes.
I asked I wasn't sure, but I asked our attorney, in our resolution, whereas the allegation 1 made findings in Exhibit 1 and allegation 2 made the findings in Exhibit 2, that would it not be clearer that the findings be part of the resolution?
Thank you, Mr. Carroll.
which I can fix in the signed version. This is separate from the question that you may have. But, so in the draft that you have, there are, on page 2, of what I gave you, the third whereas and the fourth whereas, instead of colons there, those should be semicolons. And then probably also the fourth whereas. But that's separate from the question that may come, during your discussion. But yeah, so if those were, because it looks like there's information that's supposed to follow that, but it's not. So if the board approves a version of this, I'll correct it for the execution version.
So to Mr. Carroll's question, is that going to be included as well, Mr. Malone?
I didn't actually hear Mr. Carroll's question.
Mr. Carroll, you want to restate your question?
The question was, in order to make it clear, the third whereas, the investigation for allegation 1 made the findings reflected in Exhibit 1. Semicolon, just a brief explanation of what the findings were. The same for whereas number 4, investigator for allegation 2 made the findings reflected in Exhibit 2. Again, putting in the resolution, a synopsis of the findings.
I mean, if that's the board's pleasure, I mean, it's your resolution. We can certainly, if what you're saying is that we would cut and paste in that location the findings from each of these kind of as is, we can absolutely do that in the version that the board would sign. So the board could approve it if that's the board's pleasure. Assuming that language is inserted in those 2 locations, I can then create a version to be signed that would have that cut and pasted in that location. That's not a problem.
Is that the board's pleasure to have Mr. Malone do that in our executed document?
Would these documents, excuse me, I'm calling one Exhibit 1, one Exhibit 2, is that correct?
Yes,
The 2 documents that you gave us tonight are Exhibit 1 and Exhibit 2.
correct. Yes, ma'am.
Would these be attached to the resolution?
That's the way I had drafted it, and I still would probably recommend that we
Okay,
attach
I want to
those.
make certain that they're
Okay.
attached.
Yeah, that would make sense to me that we would, if that's okay with the board, that we would attach those. But if the board wanted to support Mr. Carroll's position, we could easily cut and paste that language in here in a minute, and then the board could sign that version.
I think that if you want to cut and paste that, Mr. Malone, and add that, but also add the entire exhibits attached like you had mentioned, I think that would work. Is that okay with the board?
When you use the word allegation, you have allegation 1 and allegation 2. Would that be the findings?
So allegation 1, as it's defined here, it just points to the information in the first whereas, and then allegation 2 is the second whereas. Now those correspond to then what would be Exhibit 1 and Exhibit 2.
Okay, I see. All right,
Right.
thank you.
Yes.
I understand now.
So for the sake of time, I would entertain a motion to accept this resolution with the additions that we have just discussed, adding the findings abbreviated in the resolution, and then attaching the full Exhibit 1 and Exhibit 2 to the resolution.
So moved.
Motion by, no, Ms. Sessoms made the motion. Mr. Byrd made the, seconded. At this time, I'll open it up for discussion.
I just want to clarify to make sure, because that on the first exhibit, which is considered as allegation 1, which deals with Mr. Ronald Johnson recording discussions among board members during a closed session meeting. I just want to reemphasize that the Exhibit 1, along with information within this document, states that Mr. Johnson was interviewed on August the 1st of 2022 about the concerns about recordings in closed session, August the 1st, 23 days ago. The other Exhibit 2 is the exhibit or the article that deals with the email that we received from a parent. And that parent sent that email on August the 11th to the board with great concerns about what was being done to their two children, his two children. It is also evident in the Exhibit 2 that it was on July 1st that Mr. Johnson contacted or in a discussion, mentioned to the principal of the school that as the conversation was concluding, Mr. Johnson raised the issue of student assignment. So I'm just going back in time and just trying to make sure I'm clear on those dates, that this was done several weeks or months ago.
Mr. Malone, that is correct based upon the exhibits that are before us tonight, correct?
Yeah, that is correct, yes, yes.
Allegedly done based on 100% hearsay, correct?
Okay, and I'd like to address that. So you are discrediting one of our principals, and you're discrediting Tharrington Smith.
I'm
our
discrediting the
leading-
rumor that comprises
Excuse me,
this.
I am
Yes, ma'am.
speaking.
Yes, ma'am.
I'm speaking. Okay? And you're also discrediting Tharrington Smith, who conducted these investigations. And Tharrington Smith happens to be one of the leading law firms in this state who handle the business of school systems as well as boards of education. So you're discrediting both of those entities.
Absolutely, I am,
Okay.
because they are gathering information. They're not investigating anything. They have produced nothing beyond statements, Ms. Sessoms. They have produced nothing beyond statements, and I'm producing my statement saying that is completely inaccurate.
Sir, this is not a court of law.
Absolutely.
There is no requirement at this point other than the fact that we believe what our principals say, and we believe, or I believe, I should not say we, I believe our principals, and I believe this law firm that has conducted this investigation.
Good for you, ma'am, but I'm telling you, I deny it. This is complete hearsay, Ms. Sessoms. And again, when you can produce something of evidentiary value other than somebody heard that I said something, I'm good with that. But until then, that's what it is. You can't word around it.
Well, not everyone in a school system records each other secretly, and that is all I'm going to say about that.
Mr. Johnston, do you have any other items that you would like to make comments on tonight?
But you'll stop me when I start. Is that correct or incorrect, sir?
I'm giving you the opportunity right now to speak.
Yeah, in regards to allegation 1, like I was saying before, you have an employee who was treated in an arbitrary and capricious manner, much like the case of Tully versus Wilmington, where they were singled out on an obscure standard. You had 20 employees on a list. You, Mr. Sutton, picked out one employee and tried to take money away from that individual. During the discussion of that individual's salary, the medical condition that that individual was diagnosed with was brought up.
Okay, time out. So we spent a lot of time making sure that we were not divulging personnel information in how we presented this information. And I do think that while you have every right to speak in your defense, if you're gonna talk about employee issues, we should probably go into closed session and allow that portion of your response if it's gonna be.
I don't think you can narrow it down to a specific employee, Mr. Malone. I think it needs to be known that an employee was targeted, and that employee, I would be interested to know, Mr. Malone, if they indicated in this report that they felt like they have been targeted by members of the Board of Education. I would ask you that now. In your report, Mr. Malone, did the employee in question say that they believe they've been targeted by other members on this Board of Education beyond myself? Did that employee feel like they were improperly removed from their position and it was out of retaliation? Can I ask you that and you answer with honesty?
You have the report.
I'm talking about in the complete interview. Did that employee say that?
You have the report.
Okay.
This is the report. It's the complete report.
I feel strongly that that employee indicated that, I want to give a gender, that they believed they were being retaliated against by you, Mr. Sutton. Yeah, you can laugh if you want to, and I hope we make it to a courtroom, and I hope we can get on the stand and do this, because you singled out one employee. Notice they're not jumping to your defense right now. You singled out one employee because of a personal vendetta you have, and you tried to take money from that one employee. And as much as they've had to say tonight, they're saying nothing now because they know it's true.
Again, I'm gonna use your words, hearsay, okay?
And if I had a recording, I could prove it, and I don't have a recording.
Yeah, that's probably the only one you don't have.
But that's the one you're accusing me of having.
Okay, so based on the information, Mr. Johnston, you have had many opportunities to respond to Tharrington and Smith.
You
what
certainly
call-
didn't deny that.
What you call witch hunts.
It is a witch hunt.
So,
Y'all are known for targeting employees. In June, y'all targeted one principal. You talk about discrediting principals. Y'all targeted one principal who was seeking a promotion. One of you in this room did. You targeted a principal who was seeking a promotion, and we had to bend over backwards. You were going to prevent that principal from getting a promotion. I've never targeted any employee here. I've only defended employees. No employee's ever walked in here and said, I've targeted them, where I can make an argument that you have, and I look forward to doing that. If you put this in a court of law, I'm ready, because you, Sutton, have targeted people. There's been so many principals removed from North Johnston High School because you didn't like them.
we're gonna cut the comments because that's
Because it's
irrelevant.
true.
It's not. Ridiculous.
Yeah, how many people have been moved and given
Mr.
these
Johnson,
arbitrary
enough.
That's not enough, because
Enough.
you can't handle it. You
Oh,
can't
my
handle
God.
it.
Enough.
Again, make me.
Enough. At this time, we'll go to a vote to approve this resolution. All in favor, say aye.
Aye.
All opposed? Motion carries 6-1. At this time, I would like to remove Mr. Johnson from the Finance Committee and the Policy Committee. He is welcome to attend those meetings, but he will not participate in any votes or anything of that magnitude.
You don't vote in those committees.
You have approval. You have a voice in that, but you don't. Mr. Malone, do you have everything you need for the letter for the DA? You and I can work on that separately.
What I understand is that we would include the two exhibits that we discussed tonight. If there's nothing else, then yeah, I think I've got what I need.
Mr. Malone, I would like to request that you include in that letter to the district attorney that based upon the investigation of Mr. Johnson by the Smithfield Police Department, is there any information or evidence that would warrant Mr. Johnson's removal from the school board?
What that is, but I can certainly include that in the letter if that's the pleasure of the board.
Is that the pleasure of the board?
We don't know. I don't know. So I can't speak one way or the other, but we can certainly include it in the letter if that's what you want to do.
I'd like to make a motion that that's included in the letter.
We have a motion. Do I have a second? All right, we have a motion and a second to include this in the letter. All in favor, say aye. Well, you want a discussion?
This would be what we, the emo, is that what you're talking about? Yeah. This would be asking for an emotion. Okay.
So obviously, it's a confidential personnel matter to which we have no knowledge of what's happening. But to the extent that the district attorney's office knows what's happening or may be able to find out what's happening and can decide on her own whether she believes it would support.
Let me help you. Let me help you. What's going on? All right, in general, when a government agency does an investigation of an employee, it's covered under what is called garrity rights. Garrity rights allow government employees to be interviewed by their employer without any type of criminal prosecution associated with that. Now, with that being said, I think what you're seeking is under a criminal investigatory nature. So therefore, you wouldn't be. So Rod, can you come back in 20 minutes and tell us where I'm right? But yeah, what you're doing.
Okay, sir, let me explain to you. There are several different options for a district attorney to remove a school board member. One is criminal, but the other is also called an emotion. An emotion, for those who may not know what an emotion is, that is where it is believed, the DA believes that a school board member is either a liability to the school board, or if that member of the board is, has broken public trust, has violated public trust. And so, based on the investigation at the police department, there may be findings that she knows about that would contribute to an emotion.
And when you do an A motion, the burden of proof is significantly high. So this hearsay stuff you're throwing around with an A motion is not gonna work. But you know what, go do what you do, and let's just get this done.
Okay, we have a motion and a second. All in favor, say aye. Aye. All opposed?
Yeah. Thanks, dude.
Motion carries 5-2. With no further business to come before the board tonight, I'd entertain a motion to adjourn. Motion by Mr. Carroll,
Second.
second by Mr. Wooten. All in favor, say aye.
Aye.
All opposed? Motion carries 7-0.